Opponents of third-party litigation financing often argue that such financing is contrary to long-held principles that have their roots in English common law. But a traditional principle is not valuable just because it is old. Changing circumstances can provide good reasons for modifying even the most long-standing principles or rules. This kind of changing approach to litigation financing is evident in the United Kingdom and Australia, two countries with a legal system also founded in the English common law tradition. These two countries provide an example of how to reform American law so that the benefits of litigation financing can be unlocked for both litigants and the justice system. In the United Kingdom, third-party funding of litigation was unlawful until 1967. Then reform legislation repealed criminal statutes that had prohibited champerty and maintenance. These were common law concepts describing officious intermeddling by third parties in pending cases. As a result of these reforms, third-party litigation financing will be evaluated on a case-by-case basis. It will be disallowed only when it is shown that a particular litigation financing agreement was contrary to public policies. These public policies related to whether the funder was entitled to an excessive share of the recovery, whether the funder had too much power in controlling decisions about litigation strategy, which should be made primarily by the litigant, and whether the agreement was consistent with the objective of increasing access to justice. In a recent English case, the court considered the legality of a funding agreement. The agreement gave a third-party funder the opportunity to counsel the claim holder and lawyers on settlement, advise and consult with damages experts, and provide forensic accounting services. The court upheld this agreement because the funder did not control fundamental decisions about litigation. Australia has embraced litigation financing even more enthusiastically than the United Kingdom. In most Australian jurisdictions, third-party funders are allowed to control any and all aspects of the litigation. In general, Australian courts have concluded that courts need not control how a litigant pays for his legal costs. This is because other doctrines exist to prevent the misuse of the judicial process by non-parties to a case. A recent decision by the High Court of Australia confirmed the third-party financiers condition their funding on having significant control of the litigation process. In this case, the court permitted arrangements allowing funders to provide all instructions to the solicitors, settle the claim for no less than 75% of the amount claimed, and receive up to 33.3% of any amount that the claimants recovered. It concluded that such conditions were neither against public policy nor an abuse of the court's process. In fact, a concurring opinion pointed out that permitting some control by litigation funders can actually improve access to justice. They said, "A litigation funder does not invent the rights. It merely organizes those asserting such rights so that they can secure access to a court of justice that will rule on their entitlements one way or the other according to law." In addition, the opinion noted that it made sense for funders to have some control over the litigation process, given their stake in the outcome of the case. In the next video, we will explain how an active role by litigation funders can improve the ability of litigants to defend their rights. If you need help with litigation funding, call or email me today.